Our next item for consideration is H.R. 3766, a bill to prohibit the District of Columbia from acquiring tribunals in court or administrative proceedings in the District of Columbia to defer to the mayor of the District of Columbia's interpretation of statutes and regulations, and for other purposes. The clerk will please designate the bill.
H.R. 3766, a bill to prohibit the District of Columbia from requiring tribunals in court or administrative proceedings in the District of Columbia to defer to the mayor of the District of Columbia's interpretation of statutes and regulations and for other purposes.
Without objection, the bill should be considered as read and open for amendment at any point. Without objection to order, the chair recognizes himself to offer an amendment in the nature of a substitute. The clerk please designate the amendment.
An amendment in the nature of a substitute to H.R. 3766 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purposes of further amendment. I now recognize myself for a statement on the bill and the amendment. I support H.R. 3766, which makes sure District of Columbia residents receive impartial justice from the D.C. courts in their disputes with the D.C. mayor and D.C. agencies. The D.C. Council would like something different. Twice since the United States Supreme Court landmark 2024 decision in Loper Bright Enterprises versus Raimondo, and the council has passed legislation to put a thumb on the scale in favor of the mayor and D.C. agencies when they are sued over their action. The council's legislation did that by requiring D.C. courts to defer to the mayor and the agency's interpretations of D.C. laws and regulations. This kind of deference is inherently unfair to citizens who challenge overreaching government action in court. For decades after the Supreme Court's decision in the 1984 case of Chevron versus Natural Resources Defense Council, federal courts granted this so-called Chevron deference to federal agencies when regulated entities fought back in federal court against agency overreach. Over the years, Chevron deference fueled power grab after power grab by federal agencies as courts stood aside, deferring to agency interpretations of the law. Thankfully, in its decision, the Supreme Court finally recognized the error of its ways and overruled Chevron. But the D.C. Council wants to ignore that wisdom and insist that Chevron deference live on in the D.C. courts, denying justice to D.C. residents. Congress should intervene by prohibiting the use of Chevron deference in the court, which is precisely what this bill does. It makes no sense that people in D.C. courts still have to deal with Chevron deference while people in federal courts just down the street get the full benefit of the Supreme Court's Loper Bright decision. I want to thank Representative Hageman for her leadership on this issue. I urge my colleagues to support this legislation and recognize the ranking member for his statement.
Thank you, Mr. Chairman. House Democrats certainly opposed this bill on this committee. It's another attack on the over 700,000 D.C. residents and on democratic principles. This year, the Republican House has passed 9 bills to repeal or amend local D.C. laws, and we know these bills are pending on the floor calendar. As a reminder, again, D.C. has more residents in 2 states, pays more in federal taxes than 26 states, and D.C.'s locally elected officials are accountable to D.C. residents. Local leaders should be empowered to address local matters without Congress interfering, and we've said this many times. The bill in front of us, which we did not hold a hearing on, we know cancels a recent D.C. law that required D.C. courts to defer the D.C.'s government interpretation of laws or rules. The bill would result in more lawsuits, not less, and increased legal uncertainty. I urge my colleagues to oppose H.R. 3766. I yield back.
Gentleman yields back. Does any other member wish to be heard?
Ms. Norton, sir.
Who?
Ms. Norton.
Ms. Norton. Chair recognizes Ms. Norton from Washington, D.C.
Mr. Chairman, I strongly oppose this amendment. This undemocratic and paternalistic bill. This bill would repeal the District of Columbia's review of Agency Action Clarification Amendment Act of 2025 and prohibit D.C. from enacting such a law in the future. This bill would further restrict D.C.'s authority to enact and carry out local laws and policies. The D.C. local government is under unprecedented attack by Republicans in Congress and President Trump. This Congress, Republicans have introduced nearly 90 bills, amendments, and riders to repeal, block, or amend local D.C. laws and policies. The over 700,000 D.C. residents, the majority of whom are black and brown, are capable and worthy of governing themselves. If residents do not like how the members of the DC Council vote, residents can vote them out of office or pass a ballot measure. This is democracy. If DC residents do not like how the members of Congress vote on local DC matters, residents cannot vote them out of office. That is the antithesis of democracy. I ask unanimous consent to enter into the record a joint letter opposing this bill from the DC mayor, the DC Council chairman, and the DC Attorney General, all of whom were elected by DC residents.
Without objection, so ordered.
The substance of this bill should be irrelevant, since there is never justification for Congress to legislate on local DC matters, but I will discuss it. This bill could radically change how local DC laws and regulations are interpreted. For decades, the local DC courts have deferred to the DC executive branch's reasonable interpretation of ambiguous statutes and regulations. However, after the U.S. Supreme Court's Loper-Bright decision last year, which overruled Chevron, a question arose about whether the local DC courts would overrule their own long-standing deference precedent, which was similar to Chevron deference. In response, the DC Council enacted the Review of Agency Action Clarification Amendment Act, which codified that long-standing local precedent. DC residents have all the obligations of American citizenship, including paying federal taxes, serving on juries, and registering within the Selective Service. Yet Congress denies them full local self-government and voting representation in Congress. The only solution to this undemocratic treatment is to grant DC statehood. The DC statehood bill, H.R. 51, grants DC residents full local self-government and voting representation in Congress. H.R. 51 reduces the size of the federal district from 68 square miles to 2 square miles, consisting of the White House, the Capitol, the Supreme Court, and the National Mall. The residential and commercial areas of DC would be a new state. I urge members to vote no on H.R. 3766, Free DC. Yield back.
Gentlelady yields back. Chair
Chairman.
recognizes Representative Jack.
Thank you, Mr. Chairman. I ask unanimous consent to enter into the record the following letters of support. A letter of support from the National Taxpayers Union for H.R. 6329, the Information Quality Assurance Act, and a statement of support from the Data Foundation for H.R. 6329, the Information Quality Assurance Act.
Without objection, so ordered. Any other members seek recognition? Seeing none, the question is now on the on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now in favor of reporting H.R. 3766 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported as amended.
Recorded vote, Mr. Chair.
A recorded vote is ordered as